All right, let's call the next case.
SJC-11424, AJ Properties LLC v. Stanley Black & Decker, Inc.
Oh, God.
Yes, good morning, counsel.
Good morning, Mr. Chief Justice, Associate Justices. May it please the Court, my name is Gerard Butler. Along with Andrew Black, I represent Stanley Black & Decker in this matter. This case before the Court is a certified question from the United States District Court. Judge Saylor has asked this Court to answer the question whether he properly applied the equitable principle mentioned, pointed out in Caronto v. Silverman from 1963 to the facts of this case. I would suggest the short answer is no, because in this case, the rights at issue are not a security interest. They were formerly a security interest, but once the surety breached the security interest, Stanley's rights were nothing more than an unsecured creditor.
But, Mr. Butler, I'm looking for it right now, and I'm not sure I'm going to be able to find it, but my memory of Judge Saylor's memorandum connected to the certified question was he said nobody disputes that, he said, I have found that this goes along with the rest of these things, and nobody disputes that. So I don't know why that isn't the end of this.
Justice Bosford, I agree with your concern that if Judge Saylor had found that Stanley specifically intended to assign its breach of contract rights, I don't belong here.
Well, but that's not what he says. He says in his memorandum, he says that it is the debt that is secured by the mortgage.
The debt was secured by the mortgage, and the debt was Vargo's debt, and that was certainly assigned.
No. He says the debt, and then in parenthesis he says the
Performance bond?
Performance bond was secured by the mortgage. He specifically places the performance bond into the category of it being the debt in the analysis.
Justice Spina, I agree that the court can certainly interpret that this way, but I would suggest strongly that Judge Saylor did not find that Stanley specifically assigned the performance bond or its rights against United Capital to Wyman Gordon back in 2002. Otherwise, we never reach equitable principles here. If, as a matter of law, just rules of contract interpretation, looking at the unambiguous contracts that were negotiated by Goodwin Proctor, who represented Wyman Gordon, and Stanley's lawyers, if looking at those agreements, Stanley intended to assign its rights to Wyman Gordon, Judge Saylor never gets to the equitable principles. So that's why I strongly suggest he did not find that, although the wording that Justice Spina refers to is there. What I suggest Judge Saylor did was initially, he did have those words in the initial summary judgment memorandum.
But we're not sitting in review of what Judge Saylor did. He has presented us with a set of facts, which we assume is true, and then he asks us a question. We apply what we understand our law to be to the facts that he has set forth. Whether he's right or wrong, I think, is not for us.
I agree. I agree with the court in that. But what I'm saying is, Judge Saylor has asked this court whether or not Caronto applies to the facts of this case. The answer is no. The court says, Mr. Butler, why should I even get to that question? Judge Saylor must have found, under law, Stanley intended to assign its rights. The case is over. The question is not properly before us. I would suggest Judge Saylor did ask this court this question because he did not find, as a matter of law, that Stanley intended to assign the breach of contract rights. That's what I'm saying.
Could this not just be an instance of belt and suspenders?
I would suggest no, Justice Lenk, because Judge Saylor says in that memorandum, in support of the certified question, the answer to this question is dispositive. You answer no to this question, Stanley gets the judgment it truly deserves. So it is dispositive. He did not say this is belt and suspenders. What he says is this answer is dispositive of the dispute, and that's why I suggest that he did not find Stanley intended to assign the rights. Indeed, I'm not asking to review or second-guess his findings. What I'm saying is, if you look at the record, no rational juror, no rational finder of fact, I should say, could conclude Stanley intended to assign its rights. That's why I suggest Judge Saylor did not make that finding. Initially, there was confusion with his summary judgment order. I asked for a motion to reconsider. When that was denied, I asked for permission for an interlocutory order to go to the First Circuit because I stated, if the court is finding that Stanley specifically intended to assign its rights, then respectfully, it's an abuse of discretion because there's no evidence from which the court could conclude that. The judge said, I've got a better idea. You don't want to go to the First Circuit. What we need to do, I need to refer this question to the SJC because that's dispositive here. I am using Coranto, an equitable principle, to find that as a matter of law, Stanley's rights were assigned to Wyman Gordon back in December 16, 2002, and that's what the question says.
Yeah, but I'm sorry, I'm still back with Justice Spina. If the sentence says, the court interpreted a provision in a mortgage rider to find, I take it as a fact, that the performance bond was indeed among the obligations that were secured by the mortgage.
There is confusion there, Justice Botsford. First of all, the performance bond was not an obligation, any more than it's a right. The performance bond is an instrument. That's why it's inartfully worded.
That's for somebody else. That's not for us to decide.
I agree, and that's what I am arguing is that Judge Saylor intended this court to answer the equitable question, whether or not the equitable principle required the finding that he made. It's not a belt and suspenders. He repeatedly says, if you answer this question, it's dispositive. So if you look at that wording, you cannot reasonably conclude he found, as a matter of contract interpretation, Stanley intended to assign its rights. That's what I'm saying. And I agree with you. We can parse the language here, and that's why I made the motion to reconsider. That's why he changed his memorandum in support of his decision, because there were some curious wording. But, Justice Botsford, there is no way we could interpret that Judge Saylor found that the answer to this question is dispositive here.
Okay, so you want...
But if I have a question back as to what he meant.
I'd rather you don't.
So you want the answer to the question, I gather, to be, as a matter of law, the surety bond or the payment on the surety bond is not, as a matter of law, assigned with the mortgage. It is a matter of the intent of the parties, and it is up to Judge Saylor to determine whether or not that was intended as part of the assignment.
That's what I would like, please. And
then you may ultimately lose before Judge Saylor. You think you will not, but Judge Saylor could say, I think that was within the intent of the parties, and therefore, even though it's not as a matter of law assigned, I think it was intended to be part of the assignment, then you lose. But we've done our job and say it's not assigned as a matter of law. It's a question of intent.
That would be exactly what I'm looking for. I understand I'm pushing a boulder up a hill here, trying to get a resolution of this case, but if I could get the court to answer that question, that Professor Corbin described the policies that were advanced by this equitable principle, and it does not apply to this fact pattern, I would be greatly appreciative of that. Because Professor Corbin explains, and the court cited Professor Corbin in the Coranto case, but just didn't explain the principle that generally the assignment of a debt carries with it every remedy or security that is incidental to the subject matter of the assignment and could be used.
Is it a rule of substantive law, or is it a rule of construction?
I would suggest it's an equitable principle that...
Say it's a rule of law.
I would not say it's a rule of law. I think it's an equitable principle. If the rule of law, the mechanical application of the rule of law would result in an unfairness, then the court would go to the equitable principle to try to undo the unfairness.
Well, what if there's a suit on a contract, just a simple suit on a contract, a common law claim, no equity involved at all, and the court is looking for how do I interpret the language of the contract? Is this a rule of construction of contracts? Or?
No, it is not. No, it is not, Justice Spina. This is a gap filler. As Professor Corbin explains, this equitable principle exists because when you apply the law, the security was not intended to be assigned.
But I mean, the only reason why I'm sort of pushing this idea of the rule of construction is that the case law seems to say, and I think even the restatement on this point says, unless otherwise stated in the contract, this is the result in these circumstances.
Correct. And in our contract, we have an expression of the party's intent. Only the mortgage was assigned. And beyond that, as I said at the outset, the rights at issue here are not a security. They were a breach of a security. They are nothing more than unsecured rights against United Capital. So the whole policy right from the get-go does not apply. And Professor Corbin says, we apply this equitable principle when the parties overlook a security interest. They should have included it in their contract, but when we interpret the contract, it's plain and unambiguous that the parties did not intend to assign, for instance, the mortgage.
So if instead of having a mortgage and other things, there was simply a contract to remediate this environmental problem, and the only remedy that was other than breach of contract would have been a requirement of a performance bond. No mortgage, just a performance bond. You're saying that's not a security interest?
It could be. A performance bond certainly could be a security interest, and it was in this case up until February 2002. When it was breached, it was no longer a security interest. Let me change the facts of this case to a hypothetical to comport with your concern. If the performance bond was not breached in February of 2002, and Stanley entered into the settlement agreement with Wyman Gordon and assigned Vargo's obligations to Wyman Gordon, but failed to assign the performance bond that was still a security interest, the court would say, okay, I interpret the contract, Stanley did not intend to assign the performance bond, but equity requires Stanley to assign the performance bond because Stanley has no interest in this performance bond anymore. Just like a mortgage that has failed to go with the note, like in Eaton. The court says, no, you don't have any interest in the performance bond, Stanley. You don't care about it. And in fact, the assignee does. Because if you don't transfer that mortgage, or the performance bond in this case, then the debt that you did assign is diminished in value. And that's the difference here. We do not have a security interest. It was a breach. It was unsecured creditor. The Stanley was an unsecured creditor. The parties did not forget about this. They did not overlook United Capital. Wyman Gordon and Stanley, they both knew that the performance bond was there. They both knew it was breached. Yes, Justice
Is
Lang.
it breached because United Capital went belly up and would
sorry?
not either perform the remediation or pay off up to $800,000? Couldn't, and then you had to go to its receiver. So what is it about, because in the example you just gave, it sounds like if you were signing, if the performance bond had not been breached by United Capital not being there, if it had been there and was capable of performing, then you're saying it should have gone along with the...
Toronto would have Judge Saylor impose as a matter of law that performance bond goes to Wyman Gordon. In that hypothetical, it would, but not in our case because it wasn't a security interest any longer.
And it wasn't a security interest because United Capital was no longer in existence or was no longer able to do anything, or what? Why was it no longer a security interest?
Two things. One, United Capital breached by not cleaning up the property, but more so, it was insolvent.
But it's still liable on the bond, or the receiver would be liable on the bond to the extent that there's assets.
It certainly is, and we could sue United Capital, and that's an uncertain remedy.
When did
but
you
that's
get-
not a security interest. I'm sorry, Justice
When did you,
Blackford.
I'm sorry to interrupt you, when did you get paid from the receiver?
2010.
So this was after all these assignments?
Yes. 8 years after the assignments, Justice Botsford. In fact, the only party to try to collect from United Capital was Stanley, because that's what everybody intended. Wyman Gordon never tried to contact the receiver. Neither did AJ Properties after it received the assignment, because nobody intended anybody but Stanley to collect from the receiver.
Because you'd paid the $599 to Wyman Gordon?
A lot more than that. A lot more than that. I mean, Stanley lost its shirt in this thing. This was just Stanley trying to partially recover part of its damages. Remember, Vargo was bankrupt and United Capital was insolvent. This was going to be a partial recovery of damages here, and to settle the matter with Wyman Gordon, Stanley agreed to give the mortgage of little value to Wyman Gordon, and Stanley would try to get what it could from the receiver. When it could, 8 years later, it did get that some money, and now AJ is looking for a windfall here.
Your time is up. Thank you.
Thank you, Mr. Chief Justice. Thank you, Associate Justices, for your time today.
May it please the court, my name is John Mavrikos. I represent AJ Properties, LLC. I'd like to begin by addressing the question Judge Gantz posed concerning what Judge Saylor said. And I believe at page 9 of the memorandum to this court, Judge Saylor said, the court interpreted a provision in a mortgage rider, in this case, to find that the performance bond was indeed among the obligations that were secured by the mortgage. And it was, of course, the claims and obligations secured by the mortgage that was expressly assigned not only in the settlement agreement between Stanley and Wyman, but in the actual assignment document. So I think Judge Saylor did, in fact, make the finding that the performance bond was part of the assignment.
So
Doesn't that make the-
if you're right, why is he bothering us?
Yeah.
Well, I understood that the question was posed a little more narrowly. Quarento expresses a general rule that the security follows the obligation. And here, I thought Judge Saylor was asking, with specific regard to a performance bond, does the performance bond follow as other security would?
So you do adopt the sort of belt and suspenders notion, that this really isn't necessary.
I argued that before the district court. Yes, I did, Your Honor.
So it
But
sounds,
even if we, excuse me,
you go
so
ahead.
even if we answered the question no, you could still win.
I believe, yes.
It seems like both of you agree then, that this is sort of turns out to a question of intent. Is that right?
Well, I think it's more than intent, Your Honor. I believe the judge found that the express language
Okay,
assigned.
but so that may be. I mean, you could disagree on that, whether he did or didn't find that. But at the end of the day, it's interpreting the document, I mean, the instrument, interpreting what the parties meant. And it's either clear on its face or you look at some extrinsic evidence or something. But it has nothing to do with Quaranto, as far as I can tell.
I think there was a certain comfort that even if I'm wrong on my finding of the facts, by operation of law, we would have the same result in this case, Your Honor.
So you agree that the answer to the question that Judge Saylor has given us should be, it ain't necessarily so, based on Quaranto. It's not as a matter of law assigned with the mortgage, but if it is the intent of the parties that it be assigned, then it is. That should be our answer?
No, I believe that the answer should be that under the rule of Quaranto, where there is silence as to the intent of the parties, that the security, in this case the performance bond, should go with the assignment of the obligation.
So you're saying that where there is silence as a matter of law, it should be treated as if it were assigned?
No differently than any other security.
Now, if that were the case, how come AJ Properties in 2000, whenever you took over the assignment, didn't say to Stanley Black & Decker, we want to litigate this matter with the surety. The money belongs to us. We are going to take care of this ourselves. Butt out. That's not what you did. How does that reflect your understanding that that money belonged to you?
In December of 2007, AJ Properties got the assignment from Wyman. In January of 2008, we immediately intervened in a pending case where our mortgage rights were being challenged by the then owner of the property, who was another creditor of Vargo's who had taken title to the property.
Did you intervene in the bankruptcy matter?
It was not a bankruptcy matter, Your Honor. It was before the Superior Court.
With regard to the recovery on the surety?
No, there was, to my knowledge, there was no bankruptcy action with regard to the surety.
But the receiver?
There was a receiver.
Wasn't that United
Well,
Capital's
there was-
receiver?
I believe it was a liquidator, Your Honor. I'm not aware that there was a formal bankruptcy court proceeding. I understood it was merely a liquidation.
But you did not, in any event, you did not get involved in that proceeding.
Well, correct, we did not. In 2008, in 2009, February of 2009, we took the deposition of Stanley to find out what the status of that bond was, among other things. And at that deposition, Stanley's designee identified only the October 2002 proof of loss. That's before the Stanley-Wyman settlement. That's the only proof of loss that they identified in that deposition. We asked, well, what's going on with the bond? And they couldn't tell us. We then subsequently got additional documents, and that's when we found in late 2009 that Stanley submitted a supplemental proof of loss after the liquidator said, we're disallowing the claim. So we didn't know until late 2009, 2010, that there was still something in the works coming from this liquidator. Quite honestly, I think most of the parties didn't anticipate there was going to be a lot coming from the liquidation of this, of United Capital, and therefore the primary focus was on the mortgage. But as soon as we did learn there was something, which even Stanley apparently wasn't aware of at the time of the February 2009 deposition, we did take action.
It's 30B6 person may not have been, but obviously Stanley was the one that was pursuing it, right?
Well, but I would assume that the designee of Stanley would have had the obligation to learn what Stanley was doing, if anything. And that's why when they said that nothing had happened in the file since 2002, we didn't know that there was anything still pending to intervene in.
Under what equitable principle can you win? I mean, you paid $400,000 and you get the mortgage on the Burger King property. How do you end up getting $800,000 here?
Well, we, remember, not only did we pay $400,000, but we gave up our right to own this, this valuable parcel at 149 Washington Street.
You mean the one that's all polluted, that one?
Well, at that time, Your Honor, the history was, and this isn't in the record, but Wyman Gordon had the adjacent large parcel. There was an intention at the time in the city of Worcester to develop this parcel into residential and retail development. My clients were real estate developers. They saw the opportunity in this 149 Washington Street property. Vargo had obtained a second mortgage on that property. The second mortgagee foreclosed, and we were the winning bidder at that auction. Wyman was in the process at that point of undertaking to remediate the property. And so as the high bidder, we had the right to develop that property once we purchased it, but not only did we give up that right, but we paid Wyman $400,000 to obtain Wyman's rights. And I think what is significant, though, Your Honor, is that Wyman had the right to collect 100% of the costs of the remediation. That's what Stanley assigned to it. And I believe to Justice Botsford's point earlier about the $599,000, that's specifically referenced in the Stanley-Wyman settlement. And I think that's one of the reasons why it's so important that this court decide that the security follows the note. For this reason.
Or security follows the obligation.
Forgive me, yes. The security follows the obligation. Here, Stanley contributed $599,000 to the cost of remediation. Wyman undertook to contract to remediate not only its site, but Stanley's site for contamination that Stanley caused, not Wyman. And Wyman agreed to contribute $256,000 towards that remediation. Stanley got what it bargained for. It got someone else to take this problem away that it had been dealing with since 1995.
And in exchange, it gave Wyman the right to recover all of the costs of remediation, including the $599,000. And that raises the concern that if this court does not find that the security follows the obligation, you expose the principal under the surety bond to a potential double liability. Wyman is attempting to recovered the $599,000 from the surety that it assigned Wyman the right to recover. And we know that because at page 864 of the joint appendix, in its proof of loss to the
You said Wyman, you meant Black and Decker.
Stanley is attempting to collect that $599,000 from the liquidator, and indeed did collect that. In its proof of loss, Stanley specifically asks for $599,000 that it contributed, and that's at page 864.
Well, how can the answer to the question that Judge Saylor asked be yes, where in Ibanez and Eaton, we recognize that the transfer of a note does not necessarily even transfer the mortgage?
Because
the mortgage has to be a separate assignment, and then you can go to court and equitably have the mortgage transferred, but that we distinguish between the assignment of a note and the assignment of a mortgage.
I think there is no dispute here, Your Honor, that the mortgage was assigned. That expressly is set forth in the settlement and the assignment. The question is, does the performance bond also go? And I think the situation with the mortgage is distinguishable because I understood this court to have made the decision in Ibanez and Eaton in large part because of the statutory power of sale that the legislature required that the mortgagee or the party foreclosing on the mortgage had to have possession of the mortgage at the time of the foreclosure in order to have its rights under the statutory power of sale. That doesn't exist here. Those same legislative obligations don't apply. What the legislature did do in the UCC case, 9203G, and the official comments make this clear, that 9203 is codifying the common law that does say that the security follows the obligation.
But what do you say to the contention that as of 2002, when United Capital breached its obligations under the performance bond, it was no longer a security, no longer security interest?
I don't think the characteristic of the performance bond changes simply because the surety goes into receivership. As this court has said, and as the Illinois court, where the receiver was located, said, the receiver simply steps into the shoes of the secured party. So I don't think that changes it. I think there is one obligation here. The obligation in this case is to reimburse for the costs of the remediation.
And didn't Stanley do that to some extent when it paid $600,000 to Wyman Gordon?
It contributed to that, but if you read paragraph 7 of the settlement agreement, Your Honor, it specifically says that payment is being made on behalf of Wyman and is intended to be secured by the mortgage. So I think the purpose of that language, which is in the assignment provision of the settlement agreement, was intended to make clear that Stanley was assigning the rights to recover that $599 to Wyman.
So then what? You get money from the performance bond. It was more than $599,000?
Stanley did get that.
Okay, so what happens to the overage?
Well, Stanley had incurred additional costs prior to that $599. They had done some stopgap measures when Vargo walked off the job. They had done an investigation as to how it was removed. And in fact, in the Superior Court case, I brought an action to determine the amount of the damages, and that came in at $1.2 million cost of remediation, not including interest, Your Honor.
So what is your client, you paid $400,000, but you've paid nothing for the remediation, is that correct?
That's correct, but we purchased Wyman Gordon's right to recover the costs of remediation, the right that Stanley had sold to Wyman in exchange for Wyman's agreeing to undertake the remediation, to contribute $250,000 to clean property it didn't contaminate. So I think Stanley clearly got the benefit of the bargain.
Now, do you stand in the same shoes as, I mean, Wyman may have had an argument in terms of equities, but why, the AJ Properties just takes not only whatever contractual rights, but also can basically step into the same shoes in terms of equitable considerations?
Yes, Your Honor, and in fact, Stanley benefited from that, and here's why. At the time that they entered into the settlement agreement, Stanley and Wyman, one of the conditions preceding to that settlement was that Wyman be the winning bidder on that foreclosure
And you
sale.
were the winning bidder.
We were the winning bidder. So now the settlement agreement couldn't go forward, the property couldn't get remediated unless and until Wyman became the winning bidder. We negotiated with Wyman, we assigned our right to be the winning bidder to them, and in exchange took an assignment of their rights to recover the costs of the remediation that Stanley had assigned to them.
So you would say if anybody has equitable rights, it would be Wyman against you, not Stanley against you.
And Wyman is asserting no such
Now,
right.
I understand that, but is that sort of, that's what you're saying? It's because really Wyman would have some right to this money since it did the work.
Certainly.
We'll have to leave it there. Thank you.